Hi everyone, my name is Nazuha Betty Firdaus. In this video, my groupmates and I will present about Kenny On's case. In this part, I will present about the summary of the case. On June 13, 2003, Kenny was taken from a Bangsa shopping center's parking lot. 3 days later, after construction workers had been sickened by the smell of the region, the burned remains of Kenny's body were discovered in a cupboard near the new Pantai Motorway building site at Batu 7 Jalan Klang Lama. The body was pinned down with the two cement-filled tires before being set on fire. On top of the cupboard opening was a board that was half a meter broad. Ahmad Najib Aris was the convicted murderer. He was charged on July 3 at the Petaling Jaya Sessions Court. The shocking facts of the kidnapping, rape, murder, and placement of Kenny's body in a manhole before it was set ablaze during the trial shocked the entire country. A man named Ahmad Najib Aris was found guilty of the rape and murder of Kenny on February 23 in the year 2005. After he was convicted of the murder case, Shah Alam High Court sentenced him to death for the murder as well as 20 years in a jail. In 2007, his appeal was denied by the Court of Appeals. Furthermore, in 2009, his conviction and death sentence for the rape and murder of Kenny were upheld by the federal court. Eventually, 13 years after the incident, he was hanged in Kajang prison.
Next is the chronology or fact of the case of Kenny Ong. On June 13, 2003, around 8:30 p.m., Perli, which is the victim's mother, Ong Li Cheng and Ong Li Kian, which is the deceased, went to have dinner at Monte Restaurant, Bangsa Shopping Centre, BSC, Kuala Lumpur. After they are having dinner, around 10:30 p.m., Kenny Ong went to the basement car park alone to take their parking ticket in the car, a Proton Tiara with its registration number WFN 6871 denoted as P145. Meanwhile, the mother and Ong Li Cheng waited for Kenny Ong at another floor. However, she still did not show up after 20 minutes had passed. Ong Li Cheng decided to call the victim's mobile phone, but it was not answered. Her mother went to lodge a report to the BSC guard and a police report at Jalan Travers Police Station since they could not find the victim together with their car. On the same day, around 11:15 p.m., Ravi Chandran, which is witness 4, a police officer, noticed a Proton Tiara had stopped beside the roadside in Taman Perindustrian Jaya, Kelana Jaya. About 30 minutes later, he saw the car was still there. He then knocked on the car's window and observed that the driver was a Malay man while the passenger was a Chinese woman. The officer then requested for the IC and reconfirmed their identities. The Malay man verified that his name is Ahmad Najib bin Aris, which is the accused in this case. The officer then asked the Chinese woman whether she is Ong Li Kian, and she nodded. Ravi Chandran later asked the accused to step out of the car, but he refused. He then saw the victim make a praying-like gesture, so he tried to open the car's door, but failed to do so as the accused speed off. 2 shots were fired by Ravi Chandran towards the car, but attempt to pursue the car failed. Therefore, Ravi Chandran proceeded to lodge a police report. On June 14, 2003, around 12 midnight, another witnesses, Aminah binti Ishaq and her brother-in-law were on their way to KLIA. They stopped their car in front of Bangunan Bali at Jalan Sungai Way to wait for another family vehicle and saw the Proton Tiara 20 feet in front of them. A man who Aminah later identified as the accused came out from the car and asked whether he could borrow a car jack. Aminah also saw a woman in the car making gestures to her, and the woman seemed frightened. She decided to jot down the car's registration number, and the accused went off in the car after he failed to fix the tyre. Later, Aminah lodged a police report at Subang Jaya Police Station. On the same day, around 1 a.m., Azizam bin Ismail, a technician, stopped at a road construction area at Jalan Klang Lama to rest before going back to his office. He noticed a Proton Tiara identified as P145 and saw a woman in the car, lying down in the back seat with no clothes on and her breasts exposed. He decided to take the mobile phone, which belonged to the deceased, and took a slim bag with a Maybank Yippee logo. The bag contained 3 condoms, lighter, cigarettes, ball pen and paper. Around 8 p.m. on the same day, Constable Muhammad Zulkifli found Proton Tiara behind a shop at Jalan Petaling Utama 1, Petaling Jaya. He discovered that the car was unlocked with a flat front tyre, and he also detected a lot of blood stains at the back seat of the car. He then brought the car to Petaling Jaya Police Station for further investigation. On June 17, 2003, around noon, Isun Tai, which is witness 6, found a burnt body in a manhole at Batu 7 Jalan Klang Lama and immediately called the police and informed them of the discovery. Meanwhile, on the same day around 10:20 p.m, while DSP Amidon bin Anan examined the car, he found that the rear seat was heavily stained with blood, 6 strands of hair and an unpaid parking ticket in the car. Kasinadan Nadesan, a pathology expert, took a vaginal swab from the deceased and based on the DNA test by Primulapati, the accused semen was found. Kasinadan also conducted an autopsy of the deceased and found a piece of cloth tied around neck and both of the deceased's hands were tied with a cloth. The strangulation by cloth around the neck was the cause of death of the deceased, and Kasinadan did not deny the theory that she died due to bleeding in the abdomen caused by sharp weapons. Furthermore, the color, texture and composition of the cloth tying the deceased's hand were the same with the cloth at the accused's workplace, and according to Sivakumar, a masked storekeeper, the accused usually comes to work wearing a sling bag with a Maybank logo. On June 20, 2003, Inspector Ahmad Razali inspected the accused's house at Lot 122, Jalan Pantai Permai 6, Kampung Kerinci, Pantai Dalam, Kuala Lumpur, and found a pair of jeans which had bloodstains, a belt and a blue cap. Based on DNA test, the blood matched with the deceased. Furthermore, based on analysis of 2 forensic experts, which are DSP Amidon bin Anan and DSP Muhammad Noor bin Ahmad, it is confirmed that the man in the CCTV footage obtained from BSS parking lot is the accused.
On June 20, 2003, Ahmad Najib was arrested. He pleaded not guilty to the charges of murder and rape. During the trial, the prosecution presented evidence and argued that Aris had followed Ong to her car in a shopping mall parking lot, abducted, raped, and murdered her. The defense in turn argued that Ahmad Najib was not guilty and that the evidence presented by the prosecution was circumstantial and that there were inconsistencies in the testimony of the witnesses. Regarding the charge of rape, intercourse was proven to have taken place, but the question demanding an answer was whether the evidence provided proof beyond a reasonable doubt that it was without the free consent of the victim, and it must be decided on circumstantial evidence. The fact that the victim was abducted by the appellant, who was a stranger, when the victim was engaging in the innocent activity of getting the parking ticket from her car, and ended up being driven in a state of fear to meet her awful fate by the appellant, who had set in his mind to accomplish his designs on her, it was impossible to entertain any doubt that the intercourse was with consent of the victim. The conviction for the charge of rape was therefore right. As regards the charge of murder, the appellant argued that the cause of death was unspecific. The mens rea, that is the intention to cause death, was uncertain because it would depend on the actual cause of death. Whether the cause of death was strangulation, or the infliction of an injury on the victim that caused the internal bleeding, or whether it was a combination of both, or whether it was burning of the victim, who would have then been alive, placed in the manhole, it was the appellant who did whatever it was that caused the death of Ong. The evidence was viewed as a whole, including the fact that the appellant had raped the victim. There would be no basis for entertaining any probability that everything the appellant did was without the intention of causing the death of the victim. The conviction for murder was therefore right. On February 23, 2005, Ahmad Najib Aris was found guilty and sentenced with imprisonment of 20 years and 10 strokes of the cane on top of a death sentence. The defense filed an appeal in the basis that the death sentence was too severe, but was dismissed by the Court of Appeal. In January 2007, he filed another appeal to the federal court. Ahmad Najib failed to obtain the federal court's permission to review his conviction and death sentence, which set in stone his fate that he was going to meet. Finally, on September 23, 2016, Ahmad Najib, who was then 40 years old, was executed by hanging at the Kajang prison.
The ambulance stayed with the victim Alice after she began to bleed, as shown by the victim's blood stains on her pants. The fact that there was so much blood from the deceased on the backseat of the automobile demonstrated that the source of the bleeding occurred when the victim was seated in the backseat of the vehicle at about 1 a.m. on June 40, 2003. This evidence led to the inevitable conclusion that the appellant was the one who started the bleeding, strangled the victim's neck with a ligature, bound her wrist, though not necessarily in that order, put her in a manhole, and set fire to her or her body. These arguments were supported by DNA profiling, the outcomes of which were acquired via the use of a computer. The papers in question, which were generated by the computer which created those findings, or from which those results were obtained, were argued against being admissible as evidence under Section 90A of the Evidence Act of 1950 on behalf of the appellant in the appeal. However, this court had determined it is not necessary to obtain a certificate under the subsection to demonstrate that a document was produced by a computer during the course of its normal use. Instead, as long as there is proof that a document was produced by a computer, subsection 6 applies to deem the document to have been produced by the computer during the course of its normal use. There was no doubt that a computer created the DNA documents in issue in this instance. They were thus considered to have been created by the computer during the course of its normal operation, and they, as well as the assertions they contained, were considered acceptable. Next, the chemist also found 2 strands of human head hair on the dark blue Cambridge sweater found in the appellant's house. The chemist concluded that the 2 strands of hair were identical to other strands of hair that were DNA profiled to the victims, indicating that they may have originated from the same source. So the appellant could have worn the dark blue sweater when he was with the victim. The issue that needed to be addressed in relation to the rape case was whether the evidence demonstrated beyond a reasonable doubt that the intercourse was done so without the victim's free consent. Circumstantial evidence must be used to determine if permission was given. It was impossible to entertain any doubt that the intercourse took place without the victim's free consent because the victim was abducted by the appellant, a complete stranger, while she was engaged in the innocent task of getting the parking ticket from the car for her mother. The appellant also drove the victim in a state of fear to the fateful location. Therefore, the rape charge conviction was appropriate. In conclusion, the auxiliary nucleic acid DNA now unquestionably plays a distinctive role in forensic research. DNA analysis was evolved into a new form of scientific evidence that the general public and experts are continually assessing. The findings of DNA analysis are being recognized by more and more courts worldwide, and now this technique is nearly universally accepted in most legal systems.